Thank you very much. Now, I know Andrew's going to have to be leaving here. What time? 15 minutes. So we are going to open up for questions, but one question I'd just like to throw out for Andrew, what John just said. Could Congress just solve this whole problem with the Ionia management by passing a statute that says whenever we say the word person in any statute, it means a corporation? In fact, there's a definition in the U.S. Code, 1 U.S.C. 1, that says a person is defined as a corporation. Would that take care of the problem and end of story?
Well, Congress could solve this problem, not in that exact way, but they could, as they did in the Elkins Act, say exactly how respondeat superior is going to work. They could look at the Kolstad case and say, well, we're going to have a statute that sets forth exactly how courts should be doing this so that it's not a matter of federal common law. Congress is never going to do that, but yes, they could. In looking at this issue, that obviously was one of the potential options, but particularly in this environment, I don't think that's going to be a plausible avenue. Even though, just to point out, the reform that I think is needed is not one where we say there should not be corporate criminal liability. I agree with Alice and that there is a real place for corporate criminal liability. My issue is the legal standard that's being applied, and also as a matter of law, what the authority for that is, since it's one that is coming from a common law, which is really antithetical to how we typically think of criminal law. And then just one final point on Arthur Anderson, since it was raised, which is that I wish that was the Supreme Court case that dealt with this issue, and unfortunately that case just dealt with a double mens rea requirement in the particular obstruction statute that was charged, so it really didn't deal with the level of evidence and those issues. It just dealt with that the jury was not properly charged in the obstruction statute. Getting another case before the Supreme Court, as I mentioned, is going to be difficult, but I think that's really the only hope, because until I don't think we're going to have a bold enough Congress right now, and I think the way to do it is to have judges like you raise, when the case is raised before you, to look at the issue and to raise the issue enough so that it at least is something that is ripe. And obviously from the litigant's point of view, it is to make sure that the corporate defendant is not waiving or forfeiting this issue at the trial level, which was the issue in Ionia, where the issue had been forfeited but not waived.
Now, any of the panelists want to comment on any of the topics before we...
I'd like to make a brief comment. Of course, we could go on all day, but let me confine myself a little bit in response to Ms. Fisher's remarks. I do think that one thing to bear in mind, as I'm sure everybody knows, but it's worth saying that there's a focused problem of corporate criminal liability and related doctrines. But there's also a more general problem. Now, one of the points I've tried to make is I think there is some metastasis between those two, but there are other problems out there that are quite similar. Now, whatever the cause and effect is, these problems, I think, are very serious. And we could have 2 weeks' worth of conferences discussing this whole range of problems, especially in the context of prosecutorial discretion. Now, I would urge everybody to take a look at this issue more broadly, because some good work by one of my colleagues, Mike O'Neill, who was the sentencing commissioner, and that's the only way you get the data, basically showed that at least outside of the corporate field, there is no prosecutorial discretion in the federal system anymore. The only case they decline is when they can't make the case. There are always a sprinkling of exceptions, but that's what the statistical data indicate. Now, part of that problem, I think, goes back to the era of Dick Thornburgh and the original sentencing guidelines, because that was the notion that, well, now the courts are going to exercise more control than they used to under these guidelines, so we prosecutors now don't really have to exercise good judgment. And second, and now we've had a whole generation, I would submit to you, a whole generation of lawyers through the Justice Department that don't know what prosecutorial discretion really means. They've never focused on it. And since a lot of these doctrines, as you've heard mentioned several places, rest on sound prosecutorial discretion, then it's disturbing to me that a lot of people don't know what it means. And furthermore, that there really is no way to monitor it. You can put out guidelines, but again, if you want to follow the analogy to the subject you're discussing, you would let the AUSAs take their choices, and then if they chose wrong, lock them up, right? Because that's what's really going on here in the corporate world. I remember when I was in the government, I don't think you'll mind, but I had a conversation with Taft the Fourth. I don't know what relation he is to the President Taft, but he was the fourth. Grandson, great-grandson. William Howard Taft IV, and he was then Deputy Secretary of Defense. And we were over there at Defense because, again, back in the mid-'80s, that was our big concern with corporate crime, right? We wanted to make sure the MX missiles went off, right? And so and he made the comment, he said, gee, if these kind of standards applied to people in government, we'd all be locked up.
Exactly. And
that's the truth. So you have to think about that, right? That is a profound point. That when one of the government's employees does a bad thing, right? You always say, well, gee, that was an aberrational case. There are even whole doctrines based on that, right? But now, when that happens in a business corporation, wham, right? Now you really have to think about that. That's a serious problem. And again, I think this, in another area I want to mention, not responsive to Ms. Fisher, is I mentioned it in the outline, but I didn't discuss it, is we're seeing this merge into other areas, like healthcare is a good example, I think, where we're now in the midst of essentially regulation by prosecution in the healthcare field as well. And it's really gotten out of control, and in exactly the same ways. That they go against doctors based on statistical analysis of, how many of this kind of operation or that kind of operation did he do. The carriers are accomplices in this, right? Because they say, well, let's pick out some doctors who cost us a lot of money, and then they make indictments against these doctors, right? There is no authority to go against the private healthcare system, but in effect, they're using criminal prosecution to reshape the private healthcare market in the image of Medicare or Medicaid. And it's just plain wrong. But they're doing it based on the same mentality, that we don't really have to have mens rea. We'll just call an expert that says, well, I have the opinion that no doctor would do this much, and we're going to ask the jury, anybody who's ever had anything to do with a criminal trial, which I assume is most of you, know that this mens rea is really an ideal anyway. Right? Because prosecutors go to juries on what are in essence negligence cases anyway, and they ask the jury to draw inferences from it. So among the many things I think judges can do is to try to be more strict on what juries are allowed to infer.
No, I was just going to say we ought to get to questions.
Yes, exactly. We've got about 20 minutes here, so I want to leave that time for questions from the audience, I guess. Is there a microphone? You just come down to the microphone? Is that how this works?
Microphones.
There's two microphones.
Also have microphones that we will pass to you if you would like. So
Great.
if you would just call on the questions,
just,
we will get the microphones to them.
Raise your hand, Your Honor, and I'll try to pick you.
No questions for the
there's
panelists?
one over there.
Here we go.
Plenty of questions.
Listen, you're all judges. I know we get questions from the bench all the time when we argue, so I'm sure you'll be wanting to do that now.
My question is somewhat directed at Mr. Parker's remarks, but I'd be happy to hear from the rest of the panelists. Mr. Parker calls a corporation organizational technology, which strikes me as raising the question of why then so many constitutional rights and protections have been accorded to corporations if in fact they are a mere organizational technology. And I wonder if you could expand on that, because that doesn't seem to be a very proper balancing of the civil rights of corporations with the status of corporations under the criminal law that you are bemoaning?
Well, I'd be happy to respond to that. I think the most important point to bear in mind is that, of course, the constitutional doctrines have evolved over many years, right? And over time, the concept, as I think John mentioned in passing, the concept of what corporations really are has evolved somewhat, right? But I think the key difference is corporations have never been held to have the same rights as individuals. And one of the very early rulings before the New York Central case was they didn't have a right against self-incrimination. And that seems to be the right most directly linked to criminal liability exposure. And yet they don't have it. And that's exactly what has allowed my friends here from the other side of the river, as I call them, to exploit that by demanding the corporation waive the attorney-client privilege and so forth. So that's one answer. And the answer is that when such an issue, corporations don't have exactly the same free speech rights. There is some protection for commercial speech. But again, so there's all sorts of variation out there. As a matter of fact, I think Henry Butler has co-written a book with Larry Ripstein, another panelist on a later panel, on this very topic, is sort of surveying the rights that corporations have and don't have. But a dominant theory of the corporate form today, and this is especially true in the era, as was pointed out, Arthur Andersen wasn't a corporation. A lot of the entities being prosecuted today are not corporations. They're partnerships, they're limited liability companies, they're other things. So we have a whole variety of different organizational forms out there. And so I don't think that looking to the analogy of the corporation as person is a very good policy guide, frankly, because corporations don't have all the same rights as people, so therefore they shouldn't have all the same liabilities necessarily. So I don't think there's any inconsistency in that, and I think the law is quite varied. But the key point is there are a lot of rights they don't have. And they do have due process rights. They have that. But the basic point is this. A corporation, another way to think of a corporation and an alternative theory is it's just a contract. That's really what it is, right? As I say, it's an organizational technology. It's a way to coordinate the interests of lots of people. And I think this is the destructive effect economically of things like corporate criminal liability. Everybody has a stake in this, right? Because let's face it, corporations and their variants are the most important engine of productivity and wealth that this country has developed. And we tamper with them at our peril. And in evidence, I would show the last few boom and bust cycles, every time getting a little worse.
John, you have a quick one before we get to another question.
Well, I think it's important to understand that corporations originally were not treated for constitutional law as separate entities. Under the Marshall Court, you didn't have separate status for purposes of, quote, citizenship. When the court later changes doctrine on this, it's basically to get corporations out from under so much control by the states.
By the state, yeah.
And then that allows the expansion, the creation of larger corporations. It's that triggers the Interstate Commerce Clause Act and the Interstate Commerce Act and things. So by federal courts freeing corporations from state control, it almost mandated that some way the feds would have to come on and control things. And unfortunately, there's been a lot of distortion in other areas of constitutional law. For instance, because corporations are not citizens under the Privileges and Immunities Clause, we've therefore had the expansion of the so-called Dormant Commerce Clause jurisprudence to take care of that. So the real problem is corporate organization and who has jurisdiction over this. That's the real issue, I think. It's a corporate issue, and as Jeff pointed out before, it's kind of made its way into the criminal arena because it's not been rationally dealt with otherwise.
Okay, next question.
The suggestion that the feds over-prosecute matters. I remember when New York's now disgraced former Governor Eliot Spitzer was New York's Attorney General. He said he went after Wall Street because the feds wouldn't. I mean, there seemed to be some prosecutorial discretion in your favor at some point. I don't know. It just
Well,
seems as if maybe your
Yeah.
criticisms are a bit broad.
Can I take that?
Yeah, sure, go ahead.
Thanks.
Go
Okay.
ahead, yeah. She knows the answer better
Okay,
than
thank you. First of all, thank you for the question. I do want to say, not in response to anything in specific, but my 5 years at the Department of Justice, the prosecutors that I worked with, they exercised discretion every day. They went to work. They did their job. Are there bad apples? Of course, but 99.9% of the people that I worked with every day were committed, dedicated, exercised their discretion, and were there, not getting paid well, to do the right thing. So I appreciate the question. And as far as the, balance back and forth, I just would say this, because it's a recent thing. If you look at 2002, after WorldCom and Enron and those cases, there was an unbelievable outcry from the public, from investors, from Congress, from the executive branch, everyone, about holding people accountable and going after the corporations that, created this. Then in 2004, 2005, the pushback from corporations were Sarbanes-Oxley too overregulated, we're paying too much for compliance, this is outrageous, stop it. And then what do we have now in 2009? Not enough regulation, we allowed this to happen with our mortgage fraud, et cetera, et cetera. So I think that it's a cycle and it's a balance, but I think that what that shows is exactly your point, is that there is discretion being given to these decisions.
Let me follow up.
John?
Go ahead.
You have a quick one?
Yeah, sure.
Look, people like Spitzer, attorneys general, has become a popular thing to emulate federal prosecutors, one. But the fact of the matter is, if you don't like Spitzer, you can leave New York. If you don't like federal prosecutors handling cases, even if you leave the country, they assert extraterritorial jurisdiction over you. Moreover, in our state, the Attorney General tried to emulate Spitzer, and he prosecuted some outrageous cases after Katrina, and the public had its say. It voted him out of office. The problem is with especially local U.S. attorneys, there really is no accountability. As Alice pointed out, there isn't control from Washington, and that's not a federalism issue because it is a separation of powers issue. We do not have an additional 93 branches of the federal government called U.S. attorneys' offices. Under separation of powers, they are only accountable through the President of the United States. And if the Attorney General cannot properly make the argument to those that are appointed that you serve because you are the extension of the Justice Department and that is in the executive branch, then you're appointing the wrong people.
Yeah, in fact, one follow-up is that one answer to your question is a lot of this has gone underground in recent years, and I think that's an important fact to bear in mind through these deferred prosecution agreements and so forth. So, for example, when I did the first ever study of the rate of federal criminal prosecution of corporations back in the mid-'80s, there were 400 a year prosecuted, about 300 convicted. Today, the number is down to 200. But that doesn't mean there's less activity. It means it's underground. It's not going through you all. And so I think that that is a factor to remember, and that's what limits the ability, I think, of judges to operate on this problem to some extent. So that's part of the answer, I think, to your question.
Great. Was there a question over here at the microphone? Yes.
There's been a lot of emphasis on federal cases. And what I have in my own area of practice would be, not a practice, but as a judge, is the fact that we have responsible officer matters, like in tax matters, where we go after the officer of a corporation, both for criminal and civil liability. And I just wonder if you have any comments about that.
Thank you. No.
Anybody want that one?
Okay.
Question.
Over by the over here. I'm sorry, you got the microphone. Yes, against the wall.
Did you want to answer that last question? I don't want
Well, I can say something about it if you want.
Go ahead.
One of the, I think that this officer doctrine sort of illustrates how complex this problem is, because one of the, I think, fairly good critiques of the Sarbanes-Oxley system is that by expanding that doctrine, you essentially are driving responsible people out. and you end up with cowboys who become the vice presidents in charge of going to jail, and that really isn't a sound law enforcement strategy.
In fact, there's been a law review article written about that.
Yeah, by Lerner and Yaya.
Exactly. Yes, over there.
Well, the setup for my question is that we've seen increases in criminal prosecutions of corporations in our state, whether that's expressive retribution or political considerations, I don't know. But I was wondering, from your perspective, we're going to talk a little bit tomorrow about Professor Posner's book concerning judicial decision-making, pragmatism, and consequences. Maybe if you could talk about it, what you think, from your perspective, when we make these decisions that have seemingly a lot of judicial discretion as far as these types of cases are concerned, how do you think the judges should look at it as far as pragmatism and consequences are concerned?
You want me to take her? My view is that judges, I think I had a few suggestions for judges, which was, don't forget that this is what has made us the country we are. And that's what you're fooling with here. And second, of course, you have to follow the law of your controlling courts, but as is pointed out, I think, ably by John and others, and Andrew, that you've got some leeway. And I think it's less true in the states, but still true. Wouldn't you agree with that, John, that there is in most states some flexibility for judges? I don't know, I haven't made a 50-state study.
It varies from state to state, but the audience here is better expert on that than we are. Did you want to finish up on that comment?
Yeah, I would just say that I think one of the things you can do is to hold the prosecutors to their burden of proof, strictly. That's one of the things I mentioned. Should also hold the prosecutors to their ethical obligations, strictly. And apply the law strictly.
In fact, I just want to say real quick that was done, by the way, in a recent opinion by Judge Posner in a case where a person was criminally prosecuted for changing the labels on some salad dressing that changed the best when purchased by date. And the prosecutor kept on telling the jury that this is an expiration date in terms of whether the food is wholesome or not. And Judge Posner laid into the prosecutor by name in the decision, I think U.S. versus Finella, a couple months ago, ordered an acquittal of the defendant because of the fact that, as Jeff was talking about here, that the prosecutors were clearly overreaching it in that case, and there are other examples like that. Question over here.
Yes, this country is an important but no longer the most dominant economic engine in the world. We have to live in a global economy. I would like to hear some comments upon how our criminalization of corporate conduct compares to what's going on in the rest of the world, with which we seem to be a little bit out of step criminally. And secondly, somewhat related, if we can comment on it, how are we dealing with the multinational, non-American corporation which gets enmeshed in the same problem?
We're holding them responsible. There's a recent case on that, right? The shipping case. Which case? What's the name of that case?
But in terms of corporate criminal liability.
No, this was the case. I've forgotten the name, but there was a recent case on your second point, which is this was a shipping case in which there was a foreign flag ship, right? Had the oil magic hose, right? And the point was, well, this happens at the high seas, but the rationale of the case was, well, when you pull into a U.S. port, you're subject to U.S. law. Right. And so that's one answer. Generally, and I know John is going to make some comments, I would say I've gone over to Europe to try to do battle on this a little bit. Now, traditionally, the Europeans didn't have corporate criminal liability. As mentioned, they're moving in that direction, but not to the extent that we are. Now, they have very different economic structures, I think. They already have a good deal of state supervision and control of their business corporations. That's why we're richer. Right? And so they don't, plus their criminal law system is entirely different from ours because they recognize it's just political theater, right? It doesn't, we Americans view criminal law as serious law enforcement. The Europeans view it as political theater. But I think it's the NGOs that are going to be the problem.
Okay, well, let's go back. There's been a long-standing tension between the United States and England over our extraterritorial enforcement of antitrust laws. And a European friend of mine who's written a huge book on this, on extraterritoriality, told me, he said, look, the Europeans watched what the U.S. did in asserting its jurisdiction well beyond its boundaries and figured, well, we ought to do the same thing. And now under human rights laws, Spain in particular, in indicting or trying to get some Bush administration justice officials.
Don't point at me.
Well, you were in the
It's not me.
It's not you, thank goodness.
Nobody from Spain's coming after me that I know of.
No, to the question, internationally we have a serious problem of jurisdiction when France wants to indict Google or eBay, I forget which one it was, for having the ability to buy Mein Kampf, and it violates their speech code crimes over there. Yes, there has to be some kind of international arrangement through treaty to get people within their own boundaries. But the U.S. has been at fault in extending our boundaries criminally. I mean, you know, remember Bush 1 arrested Noriega in Panama. Well, he was declared properly later on by international authorities to be a prisoner of war. That's war. And unfortunately, we are blurring the distinction between crime and war in international matters, and the NGOs, many of them, want to judicialize all kinds of war and make everything simply subject to criminal law. If that's going to be the regime internationally, it's not going to be dominated by American courts. It can't be. It's going to be dominated by some kind of international regime. And guess what? The Anglo-American common law is the minority worldwide. And if it is in terms of international democracy, it's not going to be in terms of the standards and the rights that we take for granted. In France and other continental countries, there isn't the presumption of innocence. It's quite the opposite. There isn't a jury trial. It's inquisitorial. You know, if that's the kind of system you want to move to internationally, there are a lot of people out there wanting to move us in that direction.
I think it raises a very interesting policy debate as to if we increase corporate criminal prosecutions to deal with wrongdoing here, are we causing international corporations not to incorporate here? Or are we causing capital flight? Are we causing an incentive that's bad? But on the other hand of it, our U.S. companies have agreed to play by the rules. If a foreign company comes here, why should we let them cheat and not be accountable and live to the same rules that our U.S. companies do? So I think it's a, they should. So I think, you know, it's a very complex, you could have a whole day to talk about extraterritoriality in this context, but you know, what it's based on as far as leveling the playing field for the businesses that want to play by the rules, opposed to how are we going to do that, and is it going to have an economic harm because of criminal liability? And from the prosecution standpoint, that's not a debate that's going to be had at a line prosecutor level.
I know, but here, you mentioned already that line prosecutors don't know anything about...
I never said that.
Well, that's the way I
laws.
heard it. Know anything about business.
I didn't say that.
All right.
They haven't been in business, okay? What we have now in the international arena really is the intrusion of federal prosecution into matters of international relations, and I think that's been very destabilizing.
Unfortunately, our time has run out, and some of this discussion will actually, I think, be carried over in the afternoon's panel, but I want to leave you with this quote from Woodrow Wilson, who then president of Princeton University told the annual ABA meeting in 1910 when he said, "You cannot punish corporations. If you dissolve the offending corporation, you merely drive what you're seeking to check into other forms or temporarily disorganize some important business altogether to the infinite loss of thousands of entirely innocent persons and to the great inconvenience of society as a whole. I don't know if he was talking about the Arthur Anderson case when that company went over, but anyway, I want to thank the panel for their excellent presentation, and
So thank